Today, the grand jury returned a no true bill in the matter involving the investigation of Joe Grisham, the county judge executive, on potential charges of trafficking in a controlled substance. This case was the subject of an order issued about 10 days ago, which directed that the clerk try to impanel, or actually issue summons for 50 jurors to possibly be a special grand jury to hear the case. At that time, I was in agreement with that process, and it was even contemplated that we might get a grand jury from outside Harlan County to remove the taint or suspicion of politics in the investigation. However, a couple of days after the order was entered, the matter was disseminated widely by email to the media, who published the fact that Joe Grisham was being investigated on these charges. And there was a lot of controversy here in Harlan County over the last week as a result of this being so widely reported in all the media. As a result, because of what I knew about the case, and also the fact that last Thursday Joe Grisham was taken for a polygraph examination administered by the Kentucky State Police laboratory people, and he passed that, showing no deception in his answers, that he had never given illegal drugs or transferred illegal drugs to the informant. And because I also knew that early last fall the sheriff had come to me saying that this informant had said that she could obtain drugs from Joe Grisham in his office. And he set her up with an undercover camera and sent her in to try to do that. She came back out with a pill, but with nothing on the recording that actually explained where she got that pill. Any interpretation that she was given the pill by Joe Grisham at the time depended on her credibility rather than what was shown clearly on the tape. But the sheriff came to me after that and told me what had happened and asked for guidance on how to proceed. I told him that he had to pursue it because it would be pursued against any other private citizen, and just the fact that the individual occupied an office did not give any kind of immunity, and that it should be investigated thoroughly. I also advised him that it was best if it was not kept local, and as a result, we later went to Frankfort. We talked with the Public Integrity Division of the investigative branch of the Attorney General's office, and told them what was going on and asked them to come into the investigation and take over the investigation, really. By that time, another tape had been obtained already, which was of the same sort. She produced a pill afterwards, but it was not clearly shown or explained on the tape how she got that, except for what she said. That was not on the tape, but there was not drug talk. The initial tape did not indicate that there was even any acquaintance between the informant and the county judge executive at that time. Just the kind of things that were talked about were roads and jobs, and I need help getting some past due child support from my spouse, and job programs that existed, and different kinds of assistance for needy people, and things like that. It was the kind of things that a constituent would go in and talk to a judge executive about, which was inconsistent with her story. So after the Attorney General's office became involved in it, William Stewart, an investigator there, came down and supervised a third attempt to get some kind of tape that showed an actual drug transaction occurring. Again, this was unsuccessful. The accounts that she was giving to the investigators were inconsistent, according to the Attorney General, were inconsistent with the things that were on the tape and with other statements that she was making. As a result, they asked her to submit to a polygraph examination. She declined. The Attorney General's office filed a supplemental report pointing out these inconsistencies, and also in a letter said that they felt that there was not evidence of wrongdoing, and that they were closing their case and terminating the investigation. They thought there were no criminal charges to be brought. So I knew this when that order was entered. And actually the reason that the order was entered I had talked with the judge about, actually the judge had brought it up, that this case needed to go to the grand jury because
Judge Allred?
Judge Allred, yes. Judge Allred said that this case needed to go to the grand jury because it involved a public official, and the rumors were already out there about it, and so the public needed to see that it was investigated, it was presented, and that it wasn't really a case. It was something with no evidence to support the allegations made by the informant. I agreed with that. Because I've done that before. There are cases that I want to have presented to the grand jury even when I think it's going to be a no true bill, because I want the people involved to see that it was investigated, it was presented, and the evidence just wasn't there.
So this is just an extension of public trust, basically?
Yes, right, it is. It's all dealing with public trust, that's right. And so Judge Allred had also suggested that perhaps we should get a Bell County grand jury, because that way it would eliminate some of the political element in the public's eye. I thought that sounded just fine, like a good idea. Also, I had considered stepping aside and letting a special prosecutor present the case to the grand jury, again, to eliminate that, and Judge Allred had talked about recusing himself from it for the same reason. So we were both in agreement on this. What changed all of this, I didn't think there was a hurry either. There was no hurry to do it at that point. All there were the rumors out there, but there always are. So there was no urgency. What changed all this was when on the 24th, suddenly it became a big news story about the judge's order that he had entered seeking the special grand jury and specifically stating that it was to investigate charges of trafficking in a controlled substance by County Judge Executive Joe Grisha. And when that became publicized and became a big story, it changed the landscape. It changed the fairness of it, because I knew at that point that the Attorney General's office had said there was no case. That we had sought independent participation in the investigation. As a matter of fact, the sheriff and I also spoke to an assistant U.S. district attorney to see if federal authorities were interested in being involved in the investigation, and they said no, that they didn't see any federal issue because unless it involved federal funds or something of that nature, there really wasn't federal jurisdiction in the matter, and they weren't interested in pursuing it. It was strictly a state matter. So we went with the Attorney General's office. As soon as but shortly after the story became big news last week, Joe Grisha called and offered to take a polygraph examination, said that he knew nothing about these allegations, that he had not done anything of this nature. We scheduled one, the sheriff's office scheduled one for last Thursday morning and in London, and it was done, and he passed with the report saying that he showed no indications of deception and in his account denying any activity like this. So with that done, I thought the only fair thing to do was to go ahead and present it now. Before we presented the case, I questioned the grand jury about whether they could be fair. I asked them how many of them had strong feelings one way or the other.
This is Harlan County.
Harlan County grand jury. To make sure that we had a grand jury that could fairly hear the case. And so we spent the day listening to the tapes, hearing the evidence, and so forth. And this evening they returned a no true bill. That there are no charges brought, there's no indictment. And that's the end of the matter unless something new comes up.